High net worth clients often demand absolute certainty. They want their vast wealth completely protected before a marriage even begins. The common misconception is that a prenuptial agreement operates with the strict, unforgiving logic of a corporate merger or a standard commercial contract. They assume their assets can be perfectly and permanently ring-fenced from a future former spouse, immune to any future claims. But the family court does not treat marriage as a mere business transaction. This creates an immediate friction between a client's desire for private financial autonomy and the state's interest in ensuring an equitable outcome upon divorce. In English and Welsh law, the concept of a totally impenetrable, legally bulletproof prenuptial agreement is a dangerous illusion. The fundamental legal reality is that parties cannot privately contract out of the family court's jurisdiction to redistribute assets. All financial remedies on divorce are governed by Section 25 of the Matrimonial Causes Act 1973. This is the inescapable framework. The court uses Section 25 to actively override private agreements if they contravene public policy or statutory fairness. A prenuptial agreement is not a standalone law. It is merely an influential variable injected into that strict statutory formula. To successfully advise a client, a practitioner must locate the exact statutory threshold where the private contract shatters against the Section 25 mandate. Section 25 grants the court vast discretionary powers to achieve a fair financial outcome. The absolute bedrock of this legal structure is Section 25(1), which mandates that first consideration must always be given to the welfare of any minor child of the family. Supporting this are the secondary load-bearing pillars of Section 25(2). Here, the court must meticulously weigh the parties' available resources against their future financial needs. The court also evaluates additional discretionary factors, including the standard of living, age, duration of the marriage, and contributions to the welfare of the family. These statutory factors are guided by three overarching principles derived from case law: financial needs, compensation, and sharing. This statutory architecture is explicitly designed by Parliament to redistribute wealth equitably. By its very nature, it resists attempts to lock wealth away privately. The treatment of prenuptial agreements in English law shifted significantly in 2010 with the Supreme Court case of Radmacher and Granatino. At the center of the dispute was a massive fortune and Katrin Radmacher, an heiress fighting to protect it. The Supreme Court ruled that courts should give effect to a prenuptial agreement that is freely entered into by each party, with a full appreciation of its implications. This ruling provided high net worth individuals a recognized mechanism to opt out of the default sharing of marital assets. However, embedded within the judgment is a crucial load-bearing caveat. The agreement is only upheld unless, in the circumstances prevailing, it would not be fair. Radmacher did not rewrite the Matrimonial Causes Act. It simply reclassified the prenuptial agreement as a highly significant circumstance of the case under Section 25. Even a procedurally flawless contract, drafted and signed with independent legal advice, remains vulnerable to the court's definition of fairness. The central legal collision occurs when the restrictive terms of a private contract conflict directly with a spouse's basic survival needs. The court maintains an absolute baseline. Basic financial need is an overarching, non-negotiable consideration that overrides private autonomy. A contract cannot legally leave a former spouse destitute or reliant on state benefits. Returning to the supremacy of Section 25(1), no private agreement can prejudice the reasonable housing and financial requirements of a minor child. Needs are relative to the specific facts of the case. The threshold for fairness is a moving target, not a fixed contractual number. In family law, fairness is ultimately defined by fulfilling those statutory needs, not by enforcing the strict letter of a private promise. The case of Luckwell and LaMotta demonstrates the court's willingness to tear up an agreement that fails this basic needs test. The agreement in Luckwell was procedurally flawless, yet the court overrode it because applying its strict terms would leave one party without fundamental housing needs. In the 2018 case of Brack and Brack, the parties had signed multiple autonomous agreements, yet these two were tested against Section 25(2) factors. The court found that because the agreements were objectively unfair to the wife and children at the time of the divorce, they lost their determinative power. As a result, the court was forced to step in and apply the Section 25(2) factors to generate an equitable award from scratch. When a prenuptial agreement violates the baseline of Section 25 needs, it is demoted from a governing contract to merely one factor to be balanced in the round. Prenuptial agreements do succeed, specifically when total resources drastically exceed the parties' basic needs. Once the court satisfies the foundational Section 25 requirements, like basic housing and child welfare, its redistributive mandate softens significantly. The default family law principle is the yardstick of equality, which dictates that marriage is a partnership of equals requiring a 50-50 split of generated wealth. A valid prenuptial agreement successfully interrupts this yardstick, preventing the automatic sharing of those surplus assets. These agreements can ring-fence premarital, inherited, or trust wealth, provided those specific assets are not required to keep the other party housed and fed. The contract does not lock the vault entirely. It only dictates who receives the surplus wealth after the statutory toll is paid. This mechanical reality dictates how practitioners must advise high-net-worth clients during the drafting phase of a prenuptial agreement. Lawyers must manage client expectations away from the illusion of absolute protection and toward the reality of conditional influence. To ensure a prenuptial agreement survives court scrutiny, the contract itself must proactively provide for the weaker party's Section 25 needs. The Section 25 factors act as a mandatory, inescapable safety net woven deeply into the fabric of English law. A greedy, one-sided agreement is fragile and likely to be discarded by a judge, while a fair, needs-conscious agreement is highly durable. The ultimate legal durability of any financial agreement rests entirely on its ability to satisfy the court's statutory obligation to protect the vulnerable.